exactly we're supposed to be capturing. So our advice at this time is start your discovery process now. Find everything, categorize it, and prepare to disclose it. So we're not sure exactly what this requirement is going to be, but it is pretty broad, and so it's going to take a lot of preparation trying to get that information all in one place. Also, you want to think about how to capture your clinical trial spend for purposes of the Sunshine Disclosure Act. So the information is reportable with the first report, but it's not going to be published until either the date of FDA approval or 4 years after the date of the payment. So you're going to have to figure out how that's going to work within your systems and within your solutions. Like the states, we have a number of disclosure exemptions. We have a number of disclosure exemptions under the Sunshine Act. Of course, the de minimis payment of less than $10 does not give you a lot of wiggle room because, well, the companies that we've been speaking to largely are ignoring the de minimis payment, just determining that logistically trying to get that minimum under control is going to be very, very difficult. You have to report anything that aggregates over $100 anyway. So in your preparations, you should probably prepare for capturing just about everything, and then if you can, figure out how to get that to work, that de minimis payment within your system. So product samples are exempted here, but there are separate reporting requirements under the Act. Every April 1st, you'll be required to submit your aggregate data on sampling, including the identity and quantity of the drug samples requested. You're already maintaining this information to comply with Prescription Drug Marketing Act, but the aggregate data is what the Sunshine Act requires, so you'll need to figure out how to address that. Device loans. So this is something that is relatively new, although we have a Massachusetts requirement as well. So you need to track this information for disclosure, as well as items and services provided under written warranty. And that's going to be an interesting challenge in terms of disclosure here. But as you can see, the exemptions are fairly similar to what we've seen in other rules, and not entirely unmanageable, but there's still a very broad category, as I said before, of what is required to be disclosed. So we also have some penalties that could be imposed. Failure to report, and that would be an inadvertent failure to report as you're required, can result in a fine of up to $150,000. Knowingly failing to report, on the other hand, can get a little expensive. Obviously, everybody is going to be doing their best to meet their disclosure requirements, so I don't think we really have to have anything to worry about this under the knowingly failing to report. So I mentioned earlier that the Sunshine preemption clause is limited. This sort of goes to the be careful what you wish for. While we were hoping for a unified solution to cover all states to get rid of the disparate requirements, at the same time we were hoping for a stronger preemption clause. We did not get it. And what it gives us then is a requirement that, or an allowance to the states, if you will, that they can disclose information that's not required by Sunshine, including some of the Sunshine exclusions, except for items under $10, and people and entities that are not required under the Sunshine Act. So, for example, they can still require reporting on nurses and pharmacists and so on. They can still impose gift bans and restrictions. Some of the transfers of value that are excluded under Sunshine can still be required by the state, so your advertising costs or educational items and discounts and rebates. Gift bans and restrictions are still open for states like Vermont and Minnesota to impose, and so we may see more of those coming out of the pending legislation that, as I said earlier, is being put on hold until the Sunshine requirements do come out. So that, in a nutshell, is your brain on Sunshine. As I mentioned earlier, the white paper that's coming out will have the detailed requirements, including the law attached to it. Some of you have seen my previous annotated versions of the law in all of its glorious color, and we will be including that as well. And that will give you more of an in-depth insight into what we're looking at. But I wanted to give you a background on that, and also take your questions when we're ready to get there. So it's not too bad. When we were trying to determine the title for this webinar series, we were just, how do you get around this? And people have been sort of grappling with this for quite a while, and there really are some upsides to this, honest. And we'll talk about some of those in just a moment. Most importantly, though, is that an increased knowledge of your spend does have some advantages. And our clients are already using the information that we've compiled for them and gotten them onto their aggregate spend solution as a tool for better planning and focusing of their spend. So your executive management is going to appreciate, obviously, the reduced compliance risk of having a unified solution, but also gives them a bird's eye view of spend across commercial silos, a better use of human resources. One of the questions we are posed when we go into a company is, why should we go into something automated? Why can't we use this by hand? And when we come up with the analysis of exactly how many employee hours are dedicated to just reporting 6 states, the executive management is usually rather surprised. And coming around to an automated solution is a much easier decision when they realize how many human resources are being dedicated to just 6, and then extrapolating that to 50 states. It also provides an opportunity to streamline and make the customer master database more relevant and efficient across the enterprise. The customer master, as some of you know who have delved into this already, is one of the biggest hurdles that we have in implementing an aggregate spend solution. And you'll have to get that data and information pretty much solidified in order to get this up and working. Commercial, of course, is going to appreciate the strategic insight they're getting into their promotional spend. We looked at a company that had siloed product groups, and through the process of discovery and finding all of their vendors, discovered that they had enormous redundancies with respect to the vendors that were providing services to the commercial marketing functions. The VP of commercial was actually very surprised and had not looked at this. And they were able to consolidate their use of vendors for economies of scale and saved a significant amount of money, but also got their spend source of some of these things under control a little bit more, so they weren't going out to so many companies and requiring information to feed into their solution. Introducing an automated or comprehensive aggregate spend solution is also going to give your commercial groups and your field representatives proactive threshold alerts that removes the guesswork for requirements such as Minnesota and California with their spend limitations, A number of companies have had a serious problem trying to determine when and who and how much was being spent in Minnesota. If a medical science liaison was spending $25 on a breakfast and a sales rep was buying 2 bagels and a donut for the same healthcare professional, then that threshold had been met. And the problem was trying to get that information into one place and let the sales reps and the field representatives know when they were approaching that, that threshold. Getting a solution in place is going to help you push out threshold alerts to let them know when they're approaching those and when they need to stop. No more bagels for Dr. Jones. Also providing information to your key opinion leaders with periodic reports regarding honoraria. So some companies are deciding to pre-report to their HCPs and especially their key opinion leaders on what they're going to be reporting to the states. If you do decide to pre-release your reports, then you're going to need to have a mechanism in place that will address any challenges that you receive from the HCPs. You can imagine the phone call coming in from our Dr. Jones saying, you know, yes, I did have lunch with Representative so-and-so, but I only had the hamburger, I didn't have the steak, therefore I don't understand this charge. Most of the companies that we've seen are placing this function of